4 o'clock on Friday afternoon. That is the deadline. Not a figure of speech, not a rough time frame. 4 o'clock on Friday, the 28th of August. 7 people have to hand over £9.5 million to a newspaper company. One of them is the son of the king. I want to give you that number properly, because the way it gets written in headlines does not do it justice. £9.54 million. That is the first payment, not the total. The first one. The total being asked for is $34.5 million. And here is the sentence that did the damage, written by a high court judge and published on Friday, the 21st of August. He said the conduct was unreasonable to a high degree. 8 words. In English costs law, those 8 words are close to the worst thing a judge can say about how you ran your case, and they are the reason we are talking about tens of millions rather than a manageable bill. I am Richard, and this is Richard Valentin. Tonight I am going to take you through what actually happened in that courtroom, what the judge actually wrote, and what it actually means for the 7 people named in that order. Because a great deal of the coverage this week has been about a prince, and a great deal of it has missed the person in this case whose story I find hardest to shake. Let us start with what the case was. 7 people took a newspaper company to court. The company is Associated Newspapers Limited, which publishes the Daily Mail, the Mail on Sunday, and Mail Online. The 7 claimants were Prince Harry, Elton John's husband, the film producer David Furnish, the actors Elizabeth Hurley and Sadie Frost, the former Member of Parliament Simon Hughes, and Baroness Doreen Lawrence. What they alleged was serious, not embarrassing, not sloppy, serious. According to the reporting from Reuters and the BBC when the case was launched, and later at trial, the allegations included the hacking of voicemail messages, the tapping of landline telephones, the placing of listening devices inside people's cars and inside their homes, payments to police officers for confidential information, and people impersonating others in order to obtain medical records. The period covered stories published across roughly 2 decades, from the late 1990s into the 2010s. Associated Newspapers denied every single allegation, not partially. Entirely. Their position throughout was that the claims were baseless, and their lawyers argued in court that the whole thing amounted to a coordinated campaign against the press. The trial began on the 19th of January this year at the High Court in London. It was scheduled for 9 weeks. Dozens of witnesses gave evidence. Harry flew in from California to testify in person. And last month, in July, the judge dismissed the case in full. Mr. Justice Matthew Nicklin found that the claimants had not proved what they set out to prove. Now, losing a civil case in England has a consequence that a lot of people watching this outside Britain will find startling, and it is the entire reason tonight's program exists. In this country, the loser generally pays the winner's legal bill, not their own bill, the other side's. And when the other side is a national newspaper group that has spent 4 years and a 9-week trial defending itself with senior barristers, that bill is not a bill in any sense that you or I would recognize. That bill was £34.5 million. So on Friday, the 21st of August, Mr. Justice Nicklin published his ruling on costs. And I want to walk through it slowly, because there are 4 separate decisions inside it, and each one matters. Decision 1, the interim payment. The claimants must pay £9.54 million by 4 o'clock on the 28th of August. That is 7 days. Associated had asked for more than $9.9 million. The claimant's own lawyers had argued for $7.9 million. The judge landed above the midpoint and closer to what the newspaper wanted. Decision 2, and this is the one the lawyers are all talking about, the indemnity basis. Normally, when you win costs in an English court, you have to justify them. You have to show that what you spent was reasonable and proportionate to the case. If you overspent, you do not get the overspend back. Nicklin ruled that most of Associated's recoverable costs should be assessed on what is called the indemnity basis. And what that means, in plain language, is that the burden flips. Associated no longer has to prove its spending was reasonable. The claimants now have to prove it was not. CNN reported the court describing the claimant's conduct as falling outside the ordinary and reasonable conduct of civil proceedings. That is the legal doorway that leads to an indemnity order, and once you are through it, the arithmetic gets very bad, very fast. Decision 3. No cap. The claimants asked the judge to put a ceiling on what they could be made to pay. He refused. According to the Associated Press, He said a cap would be too broad-brushed, that it would risk unfairness, and that it would be open to the charge of being arbitrary. Decision 4. The reasoning. This is where those 8 words come from. Nicklin listed what he called several features that mattered to his decision. The speculative nature of parts of the case, allegations built on inference rather than evidence, and crucially, the failure of the claimants to voluntarily withdraw serious accusations once those accusations could no longer be supported. He said the cumulative effect took the case well outside the norm, and then the conduct was unreasonable to a high degree. Now let me tell you what that combination produces, because the headline figure is being misreported everywhere. The claimants had insurance, legal costs insurance, taken out at the start, covering roughly £16 million. That was based on the budget estimates provided at the outset by Associated's own lawyers. Associated's actual bill came in at more than double that, so the exposure is not $34.5 million. The exposure is the gap. Everything above $16 million comes out of 7 individuals' own pockets, and the Associated Press put that potential further liability at around £25 million. David Bailey Vella, who chairs the Association of Costs Lawyers, told the Associated Press that the ruling could hardly have gone worse for the claimants. That is a costs specialist, not a royal commentator, a man whose entire profession is this narrow question, saying it could not have gone much worse. I said at the start that there is a person in this case whose story I find hardest to shake, and it is not the prince. Baroness Doreen Lawrence. If you are British and over 50, you do not need me to tell you who she is. But some of you watching are not, so let me say it plainly. In April 1993, Doreen Lawrence's son Stephen was murdered in a racist attack while he stood at a bus stop in southeast London. He was 18 years old. What followed was one of the most shameful episodes in modern British policing, and the reason the country eventually confronted it at all is that his mother refused, year after year after year, to let it go. She spent decades on it. She was made a baroness. There is an inquiry named after her son that changed British policing, and she was one of the 7 claimants in this case. Her allegation, as part of this group, was that a newspaper had unlawfully gathered information about her during the years she was fighting for her son. The judge found the case not proved. Now here is the detail from the Associated Press that stopped me when I read it. Doreen Lawrence's share of these costs is expected to be covered by the other claimants. Read that again. The 6 other people in this case, including the prince, including Elton John, are expected to absorb the share that would otherwise fall on a woman in her 70s whose son was murdered in 1993. I do not know whose decision that was. I do not know when it was made, or how, or whether it was agreed at the beginning as a condition of her joining. Nobody has reported that, and I am not going to invent it. But I want to say something about it anyway, because it is the one part of this story that has almost no coverage, and I think it is the most human thing in the whole file. Whatever you think of this lawsuit, whatever you think of Prince Harry, somebody in that group made sure that the bill would not land on Doreen Lawrence. And after the July ruling, it was Harry and Doreen Lawrence who issued a joint statement, the 2 of them together. They said they had come to court seeking justice and accountability and had received neither, and they called the outcome a complete and obvious whitewash. Strong words, words that Associated's own barrister, Anthony White, argued in court amounted to an abuse of Harry's position and his celebrity. But strip away the legal argument for a second and look at what that statement actually was. It was a 41-year-old man and a woman in her 70s, standing next to each other outside a courthouse, having lost. There is something in that image that has nothing to do with royalty at all. Now let me argue the other side, because every week I do this, and every week it is the part that nobody else does. I have just spent 14 minutes telling you how badly this went for the claimants. All of it is accurate. Now here are 4 things that complicate that picture, and every one of them is also on the record. 1. The judge was not impressed with the newspaper's bill either. This gets almost no coverage, and it should. Nicklin described Associated's £34.5 million claim as excessive. CNN reported the court calling it exceptionally high. One report noted the judge finding it largely unexplained and saying it raised real concerns about whether all of it had been reasonably incurred. The court explicitly said the ruling was not a blank check. So the 34.5 million figure, which is in my own title tonight and in every headline in the world this weekend, is a number that the judge himself has openly questioned. It is what Associated is asking for. It is not what has been awarded. 2. The full amount has not been decided. If the two sides cannot agree, the bill goes to a costs judge, who is a specialist whose entire job is to go through a bill of costs line by line and strike out what should not be there. Even under the indemnity standard, duplicated work and unnecessary charges can be rejected. So when you hear 34.5 million, the honest translation is this: an opening claim, subject to challenge, before a specialist, on a timetable nobody has set yet. 3. The judge did not find these people dishonest. This is important, and it is being lost. Nicklин's criticism was of how the case was constructed and how it was run, building on too wide a canvas, keeping allegations alive after the evidence moved. He acknowledged that some of the claimant's points had substance. Losing a case badly is not the same as bringing a case in bad faith, and the ruling does not say the second thing. 4. Harry has won these fights before. In 2023, he sued Mirror Group newspapers, and he won. He was awarded around £140,000 in damages, and he became the first senior royal to give evidence in a British court in over a century. He also settled with News Group newspapers, publisher of The Sun. That settlement included substantial damages and an apology. And News Group admitted that the now-closed News of the World had targeted him with phone hacking and surveillance and had intruded into the private life of his mother. So when people say this week that Harry has been on a reckless crusade against the press, understand that 2 out of 3 of these fights ended with a newspaper group paying him and, in one case, apologizing for what was done to Diana. He was not wrong every time. He was wrong this time, and this time it is going to cost him more than the other 2 put together were ever worth. Now let us put this ruling where it actually sits in the calendar, because the sequence this week is almost unbelievable. Wednesday, the 19th of August, in the evening. The Telegraph and the Sun report that Prince Harry and Meghan are moving back to Britain. 2 children enrolled in British schools for September. 6 years in California, ending. Friday, the 21st of August. Mr. Justice Nicklin publishes the costs ruling. 2 days. 2 days between announcing that you are coming home to Britain and being ordered by a British court to pay £9.5 million to a British newspaper by the following Friday. Associated Newspapers, for its part, put out a statement calling the judgment another overwhelming victory. That is a company that has just been told by a court that it can pursue the King's son for its legal bill in the same week that the King's son announced he is moving to the country where that company publishes 4 newspapers. Whatever else this is, it is not a coincidence of comfort. And I want to be careful, because I can feel the pull toward a very neat story here. The neat story is that he is coming home because he is broke. He lost, the bill arrived, and he ran. I do not believe we can say that, and here is why. The move was reported on Wednesday. The costs ruling landed on Friday. The move decision was clearly made before the ruling was published, because school enrollments do not happen in 48 hours. The King, according to NBC News, was told on the Sunday. So the causation, if there is any, cannot run in the direction the neat story wants. What is fair to say is narrower, and I will say it as an opinion, because that is what it is. This is my reading, not a reported fact. The July defeat happened. This costs hearing was scheduled. Anyone advising the claimants knew, from the moment the case was dismissed, that a bill of this magnitude was coming. You do not need the ruling in your hand to know the shape of it. So the question is not whether the ruling caused the move. It is whether the outlook did. And nobody can answer that except the 2 people who decided. Now I want to give you the things we still do not know. And I know it sounds strange to say this is my favorite part of the program. But I would rather give you 5 honest gaps than 5 confident inventions. And there are a lot of channels this week filling these gaps with things that simply are not known. We do not know how the $9.5 million is split. 7 names on the order. Not one report has established who pays what. It has not been resolved. Anyone telling you Harry personally owes a specific figure is guessing. We do not know whether the insurance pays out cleanly. roughly 16 million pounds of cover against a claim of more than double that. Insurance policies have conditions. Whether this one responds in full and how quickly is not public. We do not know if there will be an appeal. No reporting either way as of this weekend. We do not know where the money comes from. And I want to be very careful here, because this is the single most speculated about thing in the coverage, and there is nothing solid underneath it. Harry's finances are not public. There is an inheritance from his mother and one from his great-grandmother, both long reported. There have been commercial deals. There is a house in California that the Daily Mail reports the couple are not selling, valued at around $14.7 million with upkeep of $650,000 a year. But nobody outside a very small circle knows what the balance sheet looks like, and I am not going to pretend otherwise for the sake of a dramatic paragraph. And the fifth gap, which is the one I actually think about, we do not know why they kept going. Somewhere in this case, there was a moment. There always is. A moment where the lawyers came back with an assessment, and somebody in that room said we should think about settling, and somebody else said no. Nicklin's criticism points straight at it. He faulted them for not voluntarily withdrawing serious allegations once they could no longer be supported. That is a judge describing a decision point that was reached and passed. Who was in that room? What was said? Whether Harry was the one pushing or the one being pushed. We will never know, and it is the only question in this entire file that actually explains anything. Let me step out of the courtroom now, because I think the reason this story has caught hold has very little to do with law. Most of you watching this have known someone who fought too long. A neighbor who took a builder to court over 8,000 pounds and spent 30. A brother-in-law who would not settle a boundary dispute and lost the friendship of everyone on the street. A parent who fought an insurance company for 4 years and won, and was never quite the same person afterwards. You know how it starts. It starts with being right. That is the trap. Being right is not the same as being wise. And the terrible thing about a legal fight is that the more you spend, the harder it becomes to stop, because stopping means admitting the spending was wasted. Harry has said for years that this was a mission. He said he wanted to hold the British press to account. He said it publicly, many times, and he had good reason to believe it was possible, because twice before it worked. But a mission is a very expensive thing for a private individual to run. And there is one more layer, which I will offer gently. The reason this man distrusts newspapers is not an abstract political position. It began in a tunnel in Paris in 1997 when he was 12 years old. Whatever you conclude about the merits of this particular case, that is where the road starts. And there is not a person watching this who lost a parent young who would not understand wanting somebody held responsible. The tragedy of Friday's ruling is not the money. £9.5 million is a catastrophe to you and to me, and it is a survivable event for the people named in that order. The tragedy is that after 4 years and a 9-week trial and every resource that money can buy, the answer that came back from the highest court that could give it was no. And a boy who has spent 30 years wanting somebody to say yes has now been told no in the most public way available. You do not have to like him to see that. 4 o'clock, Friday the 28th. That is the next thing that happens. After that, there will be months of argument in front of a costs judge over whether Associated's bill is really worth $34.5 million, and I suspect the eventual figure will be considerably lower than the headlines this weekend. That is not defending anybody. It is just how these things go. I will cover it when it happens, and I will tell you when I do not know something, which, as you have heard tonight, is quite often. Here is my question for you, and I do read them. Have you ever been in a fight you could not stop? Not a legal one, necessarily. A family one. A dispute with a neighbor, a company, an institution. Something where you were right, and being right stopped being worth what it was costing you. Did you get out? And what made you finally do it? I ask because I think that is the real subject of tonight's program, and I think there is more wisdom in that comments section than there is in most of the commentary I read this week. If you found this useful, subscribe. Everything here is sourced, and where the reporting stops, I stop. I am Richard. Thank you for your company. Look after each other.